This is a summary of the judgment which the Supreme Court is handing down this morning in the case of Rittson-Thomas against Oxfordshire County Council. Many hundreds of schools in the United Kingdom, the last best estimate is that there are about 2,000 of them, have been built on land that has been provided by the landowner for the purpose of the building of a school under the provisions of a Victorian statute, namely the School Sites Act 1841. That statute provided an easy method through a statutory charitable trust for land to be provided for that purpose. But the Act has a twist in the tail, because if the land ceases to be used for the purposes of a school, it will revert to the landowner, or given that he or she is likely to have died, to his or her heirs. This case concerns the operation of the 1841 Act in relation to Nettlebed School in Oxfordshire. In 1914 and 1928, a Mr Fleming, using the 1841 Act, conveyed some of his land in Nettlebed to Oxfordshire County Council as a site for a school. The school was built and operated on the site for decades. But then in the 1990s, Oxfordshire County Council decided that it was necessary to provide new and improved school buildings and facilities. What the council did, therefore, was to close the school on the existing site and to move the pupils to a new school building which had been built on an adjacent site that already belonged to the council. The pupils moved across to the new premises in February 2006. The council in September 2007 then sold the original site donated by Mr Fleming to a property developer for nearly £1.24 million. The dispute is as to who is entitled to that £1.24 million. Mr Fleming's heirs claim that the money belongs to them because the land donated by Mr Fleming, under the words in Section 2 of the 1841 Act, ceased to be used for the purpose of the school in February 2006, when the school was closed on that site, so that the land and therefore its proceeds of sale reverted to them under the 1841 Act. The council argues that it is entitled to use that money to help pay off the costs of the new school building. Mr Fleming's heirs failed at first instance in the High Court, but that decision was reversed by the Court of Appeal, which found in favour of Mr Fleming's heirs and against the council. The council now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal of the council. The judgment is given jointly by Lady Arden and myself, with whom Lord Lloyd-Jones, Lord Sales and Lord Stevens agree. This decision has involved a close examination and analysis of the 1841 Act, and in particular, sections 2 and 14, which need to be read together as a coherent whole. Applying the most important past case on the 1841 Act, which was the House of Lords decision in 2005 in the case of Fraser against Canterbury Diocesan Board of Finance number 2, the Supreme Court has been required to apply, using Lord Walker's words in that case, a broad and practical approach to interpreting the 1841 Act. That fits well with the general principle of modern statutory interpretation, that a court should seek to give effect to the purpose of the legislation. A further factor pointing to the adoption of a broad and purposive approach to the meaning of the words is that the 1841 Act was drafted in the less rigorous style that was normal before the creation of the Office of the Parliamentary Council in 1869. They are the skilled drafters who now draft all primary legislation laid down by Parliament. A further relevant factor is that as the 1841 Act sets up a statutory charitable trust, it is in line with the general law on charitable trusts that one should lean towards the continuation of the charitable trust rather than its termination. The Supreme Court takes the view that on the correct interpretation of the 1841 Act, a council does not lose the entitlement to use the sale proceeds for the benefit of a replacement school on a new site by selling the original site with vacant possession. Indeed, that will usually be the most convenient way for a council to proceed where it wishes to move a school to a new site. To take a different interpretation might well incentivise courses of action by a council simply designed to avoid losing the sale proceeds, such as staggering the move of the school or using part of the original site for ancillary activities of the school, which may not be educationally or financially desirable. The conclusion, therefore, is that the site donated by Mr Fleming did not cease to be used for the purposes of Nettlebed School, even though the school had closed down on that site and been moved to the adjacent site, because it was the council's intention throughout the planning and carrying out of the move that it would use the proceeds of sale to help pay off the cost of the new building on the adjacent site. The council's appeal therefore succeeds, and the council is entitled to use the £1.24 million to pay off the cost of the new school building.